Hey, it's your old buddy Brian Parker doing another great video today. Today we're going back to the basics. One of the popular commenters' requests, or clients in general, are LVNV funding cases, and they can get tricky because they're so bad that their attorneys sometimes fight even harder when you point out how bad they are. It's just, that's all I can say. And this one's a bad one from a good place, meaning good for us. I've talked a lot about the fintech game and how that's exploding online debts, and Velocity is picking it up. Crown Asset Management is picking up the Cross River debt. Well, LVNV Funding is in the game. So what can go wrong? So today we have a good case analysis and frequent use of the linchpin litigation. I've done a couple of videos, a couple of them right there. The linchpin of your lawsuit or documents will what put you in the great settlement position or set you free or get this case dismissed. So the problems with this case are 5. Let's put 5 up. Shazam. My client was sued in the district he does not live in. What is important about that? Number 1, you can either move it to the district that you do live in, and that's the least of your possibilities. It's an FDCPA chip, meaning they now owe you $1,000 and your attorney fees and costs. So if it's a low amount debt, or it's a debt buying, like a fintech debt that was bought after many entities took a piece of it, you may get the whole case eliminated rather than have the debt collector law firm be sued, or sue LVNV Funding. They're a debt buyer and a debt collector. The debt buyer, number 2, fails to show any assignment of the debt based upon the debt collector law firm again saying, we assigned this debt from Cross River Bank, the original creditor, straight to us. Number 3, the affidavit of support makes their case worse. So in most, if not all, account stated cases, which is one we're going to look at today, an affidavit of account has to support that. And in some cases, especially Michigan, if you don't counter their affidavit, you automatically lose. So we're also going to look at number 4, the registration statement by Cross River. All these fintech loans, Cross River is the most predominant and most frequent seller. All these loans have a registration provision in their agreements that said, hey, if you want to see the chain of title of all the owners and all the companies that assigned this loan, just write us and ask us. So I've got the letter attached to my video in this case. And of course, my favorite thing that I have not said in a long time, use their documents against them. With this video at KillDebt.com, along with this video, I'll have the counter affidavit outlining all the deficits I'm going to show you. I'm showing you my case. It's every case. You can take a Crown Asset case, or a UHG case, or a PRA, or an MCM case, and use this information. I've got over 300 videos. A lot of them are debt buyer cases. You can use that technology, that information for your case. So look at this as a general analysis based upon a case. I'm going to show you how to break it down. Number 2, I'm going to give you the register letter. That's going to be assigned to this video. Number 3, securitization letter to all the securitized trusts you're going to see today. This is a big one. Number 4, I'm going to attach validation letters to this video. You can poke the bear, all these different entities claiming we own it, and they're not secure trusts. They're just companies that, you've seen Sherman Originators or Resurgent, that LVNV Funding will always set up as somehow they get the debt and gives it to them to make them a plaintiff. Number 5, I shouldn't tell you this, but I'll tell you, a motion to dismiss or more definite statement. So you create your counter affidavit, and that counter affidavit follows you through all the litigation, right? And then that goes to your answer and your affirmative defenses and your counterclaim. I did a whammy on this one. I'm filing a motion to dismiss based on the fact they don't own the debt. Because there's so many possibilities you're gonna see. And I'm gonna show you tactically, that's a way to go, man. And then 6, the show notes, so you don't have to look at this face all the time. I always say that. But so what is a linchpin? Let's put up the definition of linchpin, Shazam. And it's a noun. A locking pin inserted crosswise, as through the end of an axle or shaft, or one that serves to hold together parts or elements that exist or function as a unit. And the definition actually says linchpin in the defense's case. I did not write that. That's from a definition I got. So that is so true here. We are looking at the linchpin of their litigation, and it's just, it's a house of cards. So if you pull the right card, the whole thing topples down, right? So here is the lawsuit. I'll just give you the section that's important for you, Shazam, and that's 5 through 11. And we have to identify what is the linchpin. If we take a pleading away, a paragraph away, is the whole case gonna fall down like a house of cards? So here's the first linchpin. Unless you want to take some time to figure out what it is before I tell you. I'll just tell you. Number 6, Shazam. That on November 7, 2019, the account at issue was transferred, sold, or assigned from Cross River Bank to plaintiff. Remember, Cross River Bank is that most frequent fintech loan out there, with Upstart in the background as the puppet master, but that's down the road. You've seen my other velocity cases. First off, if you own something, you say, I bought it from Dave. You don't say, Dave kind of transferred, sold, and or assigned me something. So there's an insecurity there. It's a pleading, because the person writing this knows there's an insecurity, and so we go, well, it's this, but it's kind of this, and if we didn't qualify for this, then we got this. You own it or you don't own it. Let's look at the bill of sale that LVNV shows the debt of defendant being sold from Cross River Bank to plaintiff on November 7, 2019, as stated in our first linchpin. Remember, if I sell you a car with a certain VIN number, I have to put the VIN number in. I have to put my name. I have to put your name as the buyer. I have to put how much for tax reasons. Otherwise, the Secretary of State or whoever it is in your state is not going to register the car, or you can't own it and now you can't sell it. So it is not ticky-tacky to say, would you please put my name and my account number if you're saying it was assigned. So here's the bill of sale they produce. All right, that's not everything. It says the sellers are not named. They essentially say, you do some homework and go check out this long list below the bill of sale, but we sold it to Sherman Originator 3 LLC. All right, I'm not sure what they sold because the client's name is not in there. That's important. And it's signed by Marlette Servicing LLC as of the closing date listed on the attachment, and the attachment isn't listed to this bill of sale. Nothing in there says the defendant's debt is being assigned from Cross River Bank to LVNV. But again, let's go look at another bill of sale that was attached to the lawsuit, Shazam. Now a CIGPF1 Corp is selling something to Sherman Originator 3, the same purchaser as the other one. Don't know how that's possible. And again, where is Cross River Bank in both bills of sale that are selling, I guess, the same debt from two different entities? Maybe. So there's nothing showing the debt of defendant being sold or transferred at a minimum, and how two entities that didn't get it from Cross River are now selling it to the same entity, and why, is something that comes up in your counter affidavit. We don't know how CIGPF got the debt, and they apparently don't care either. So attached is, in a lot of LVNV funding cases, you're going to see And I've had my issues with this as far as signatures is concerned. That's the end. I'm going to discuss that. But look at this transfer and assignment. And that's Sherman Originator 3 LLC saying, and again, remember the words, without recourse. That means this thing, you take it, you can't sue us, to Sherman Originator LLC. I guess that's a separate company, of course it is. And then Sherman Originator LLC, subsequent to the above mentioned transfer, hereby transfers, sells and assigns and delivers to LVNV Funding the above assets. There's no assets, there's no debt. And look at all the trusts. Why are they in there? Because they got a piece of the action. So they have to have an assignment and they have to be identified. That's such a general pool of debts. There's nothing specific to you in that case. So there are three entities on top of all the trusts. Sherman Originator 3, and LVNV Funding. We don't know how any of them got the debt. There's a complete broken chain of title. So there is no chain of title as alleged in paragraph 6 in the lawsuit, but we're going to go to the second linchpin. Linchpin alert again. Here's the second linchpin in that complaint I showed you, Shazam, and that's number 11, that a statement of the account and an affidavit verifying the account are attached to this complaint and incorporated by reference. See attached exhibit. So let's take them at their word. What else we got? Let's look at the affidavits attached to the lawsuit that shores up their case and kills it for us. Shazam. And they, of course, title it Plaintiff's Affidavit of Indebtedness and Ownership of Account. Again, there's a vein of insecurity through all these debt buyer lawsuits. So they've got to name this thing everything but the kitchen sink. And that too, account stated affidavit. So I'm going to do linchpin on linchpin alert. We're going to have a linchpin within the linchpin. And the linchpin is number 4. Look at number 4. And so in paragraph 4, it says, plaintiff's the current owner of the account. Plaintiff's business records indicate that subsequent to the account's origination of the other owners of the account included, and there's Sherman Originator 3, Sherman Originator just LLC, but a new one, Marlet Funding Grantor Trust 2018-3. Where did they get the debt and where are they? Should they have kicked it over to someone else before it got this far? Their affidavit, as always is the case, the more they add to the lawsuit, because of that insecurity, and because of the insecurity, they add more to the lawsuit, but it just helps your case. Somehow this company is listed, this Marlet Funding Grantor Trust 2018-3 is listed as an other owner, but there's no record of that. And if they are, how did they ship it to other owners? And it is just a nightmare that's good for you. It's a nightmare for them. It's a dream come true for you. There's no proof anywhere showing this company should be in anywhere of the chain of title. The affidavit itself, now this is under Michigan law, but this applies in several states. There's got to be, if you're filing an affidavit, and an affidavit is filed with a lawsuit for many reasons. Number one, if the contract is missing, you have an account stated affidavit to make up for the missing contract. So you don't have a breach of contract, but you have an account stated claim based upon, of course, the affidavit. So that must meet certain hearsay evidentiary lines. At a minimum, it must be signed close to the date that the lawsuit was filed. It's got to have credibility. In Michigan, you've got to do it within 10 days of the filing of the lawsuit. In most of these cases, that's an impossibility, but that's the law. So we discovered, if you look on the bottom, that this affidavit was created 2004, December 4th, 2024. And the lawsuit, let me just show you when the lawsuit was filed, Shazam. The lawsuit was filed 1/24, so over a month. That's so the 10-day rule is violated. they refer to, and in that vein, they refer to my client and themselves as defendant, my client's defendant, themselves as plaintiff. They even call it the plaintiff's account stated over a month before the actual lawsuit was filed under oath. So if you make a false statement under oath, you're not a little pregnant, okay? You're pregnant or you're not. You're either truthful and filing under oath or you're not. And that is a false statement they've signed under oath. So none of that comes in. It doesn't come in because it failed the account stated statute. It's a 600.2145, at least in Michigan. Look for your equivalent statute. So that affidavit is out and Z. And if the affidavit is gone, well, that's all you've got in that complaint. It's an account stated complaint. So that's got to be in your counter affidavit also. You love me some governing law provisions. Well, we've got it. You love that video. You got so many views on that governing law provision that I'm still getting comments on either did you have too much coffee or I don't know what the hell you were saying, but everybody's loving it. So, governing law provision here, it's titled miscellaneous, but deep in it, let me just put it up, Shazam. You can see we are located in the state of New Jersey. This agreement shall be entered in the state of New Jersey, governed by the federal laws and the laws of state of New Jersey without regard to principles of conflict of laws, meaning the state that we're filing in this case it's Michigan, I don't care what you say about you get to override with your conflict of laws our law. It stays in New Jersey and it's by contract. And you can do anything by contract. It just can't be illegal. So in this case, they want it in New Jersey. So the substantive laws we talked about in my governing law provision is New Jersey. The procedural law where the judge says, okay, witness list, be here on Monday. You've got to have a answer filed by a certain date. Here's your motion practice. That's procedure, how law is, the substantive law is effectuated inside this courtroom. So you should have a New Jersey law, and this is for Ken. You don't have to go to New Jersey. Good observation, Ken. You bring New Jersey to you. And then you use the procedure. And that's going to cause conflicts of your own, and that's what you want. The more chips you have, the more problems where the judge goes, look, plaintiff, you've caused so many problems here. And this poor guy, self-represented, is eating your lunch today. So that's what you want. The assignment of the law section is a real good one in this case. Let me put it up there. Shazam. That's usually called the registration section, which means we're going to show you every assignment, every loan owner in this case. Here it's called the assignment of loan, and they're saying, hey, Marlette Funding LLC will give you proof of all the ownership in this case, of all the assignments, who owns the loan. So I've got a letter attached that allows you to do just that. All of this goes into your counter affidavit, pointing out to the court that this case is a piece of bleep. So it goes into your answer, right? Your counter affidavit attaches to your answer. I'm not doing that. I filed a motion to dismiss for this dreck under, in this case, let me put it up, Shazam, 2.116 C5 that says the party asserting the claim lacks the capacity to sue. If that's the case, and man is that the case, you get this case dismissed. Even if you lose, so you file it in the alternative. You file, Shazam, a motion to correct or strike the pleadings. The court says, you know what, Parker, it's early, I'm not going to give you that, even though I'm totally right, but they must prove why they own it. Well, the motion to dismiss was because they didn't own it and he couldn't prove it. He or she is now saying, I'm not letting you win that, but I'm letting you win the motion to correct or strike the pleadings, which is the same thing because he's telling them you got to prove it. He's got a 14-day window by law. If they don't give you the paperwork that they didn't have anyway in 14 days, you can then file a motion to dismiss and he's going to give it to you. The judge is going to give it to you. Make sure, pro tip, when you get a ruling your way, no matter if it's this or anything else, put it in writing. There must be an order. The court speaks through its orders. So then you can just say, Your Honor, they had 14 days. They don't have it. So what you've done by filing that motion, even if you lose, you've educated the court, you got them to agree there's missing documents. You put the plaintiff on the clock. They got 14 days to supply what they don't have. You set yourself up for great settlement possibilities. There are no documents anyway showing the chain of title from the original creditor to the plaintiff, so your linchpin of number 6 and number 11 are gone. So you win that case in a motion to dismiss no matter when you bring that. With this video, I got the landscaper here, I am going to add www.killdebt.com, your counter affidavit outlining the deficits. I'm going to give you the registration letter saying tomorrow let servicing. All right, show me what you got. One hand doesn't know what the other's doing, so they'll show you what they got, and it's not going to be the same as what they're claiming in the lawsuit. A securitization letter to every trust. Remember when we were going through that thing called the transfer assignment? Let me put it up there real quick. Shazam, the transfer assignment. Look at all those trusts. Send them a securitization letter. You're going to get a hit. They're going to come back and just kill the other side's case. Send validation letters to Sherman Originator, Sherman Originator 3, and even LVNV Funding. With all these entities being asked to prove ownership, you're going to have a beautiful defense. You may not need it, because I think the motion to dismiss kills this case anyway, but you always got to think down the road with litigation. I'm going to add the motion to dismiss and motion for more definite statement that I wrote, added to this. You can have it, just apply your state law and facts, and my show notes. So as the get off the stage music, or the landscaper is announcing I got to get off the stage, this is all about the linchpin. Knock out the linchpins. Remember what they defined linchpin as? One that serves to hold together the parts and elements that exist or function as a unit. The linchpin in the defense's case. You can do this. It's easy. They give you all their documents. Use their documents against them. Use their insecurities against them, and you will win this case. Go to KillDebt.com for all the word templates that we have that Natalie set up. There's going to be over 1,000 of them. So if you just want to avoid the video and looking at this face, you just go to the vaults form. Natalie yells at me about this. It's called the Documents Vault. It's got everything you need for a quick assessment. If it fits your needs, which it should, you'll have all those documents I mentioned today, and you'll kick their bleeping and win this case. All right? Go get them. Bye-bye.